If you're a green card holder in America, everything you thought you knew just changed quietly, but permanently. The law passed in August 2025 is the biggest immigration reform in over a decade, and it's already active. This isn't speculation, and it's not future planning. The rules are now being enforced, case by case, without delay. It touches every part of your status, green card eligibility, renewals, travel, taxes, public benefits, and future citizenship. If you think this doesn't affect you, think again. What you do this year could determine your future in America. Green card eligibility rules now clearer, but not easier. Eligibility for green cards is no longer subject to regional interpretation. USCIS now follows one national standard across all offices. While that brings fairness and predictability, it also increases the risk of mistakes that can destroy your application immediately. In the past, officers used discretion to forgive inconsistencies. In 2025, small discrepancies now lead to quick denials or referrals. Applications are being cross-checked with DHS, Social Security, and IRS systems to detect fraud, outdated information, or incomplete records. Even minor application errors, such as a wrong date or missing documentation, can now be considered material misrepresentation. To qualify, you must provide complete and consistent information. Employment history, family ties, residency, and identity must all align. Applicants who fail to follow the updated document checklist precisely are seeing rejections without any chance for correction. Green card seekers in 2025 must prepare thoroughly, ensuring their records match across every federal and financial database. Don't rely on old advice or outdated websites. Check current USCIS guidelines directly and seek professional legal guidance. In this new era, immigration success depends not just on eligibility, but on documentation, consistency, and total accuracy. Green card renewal, a national security checkpoint now. What used to be a routine paperwork renewal has now become a full national security compliance check under the 2025 law. Until recently, most green card renewals were automatic, requiring only an I-90 form, a payment, and biometric fingerprints. That process is gone. Every renewal now includes an FBI-backed background check, updated biometrics, and in some cases, live interviews. The government is using renewals to confirm that green card holders are still complying with tax laws, residency rules, and reporting. People with past criminal charges, extended foreign travel, or gaps in work history may now face delays or full denial. Renewals are also being used to identify fraud, false addresses, expired employment sponsors, and questionable financial records. USCIS is no longer assuming you've remained eligible. You must now prove it all over again, under tighter rules. If your green card expires within the next year, begin early, organize your history, and consult legal help if needed. Applicants are already reporting longer processing times, new interview requests, and RFEs for unexplained absences or financial inconsistencies. This process is no longer administrative, it is investigative. Be prepared for delays, questions, and greater scrutiny from start to finish. Citizenship pathway, faster for some, harder for others. The path to U.S. citizenship is still open, but the road just split. One lane is faster, the other harder. Under the new law, certain applicants now qualify for expedited naturalization if they've contributed to national or community service. Those who served in the U.S. military or worked in essential industries for 5 years may be eligible for faster processing. But there's a catch. USCIS is now applying higher standards to everyone, especially those seeking citizenship without long-term ties. Proof of continuous U.S. residency is now verified using government entry and exit logs tracked at all ports and airports. Breaks in presence longer than 6 months are flagged and must be explained or waived based on specific eligibility exceptions. The English language test now includes reading comprehension and civic knowledge to reflect more practical integration expectations. And good moral character is no longer just about avoiding arrests, it now includes tax filings, benefit history, and community impact. If you're applying for naturalization, you'll need to document every year of presence, your income, your taxes, and your contribution. Be ready to demonstrate your integration, compliance, and intent to remain. This is no longer just a formality or milestone. International travel riskier than most realize. Leaving the United States as a green card holder has always carried risk, but now the consequences are even more serious. Under the August 2025 law, DHS and CBP are actively screening returning green card holders for residency violations and abandonment. Extended absences over 180 days may trigger questioning, secondary inspection, or a formal review of your immigration intent. Officers now have discretion to refer returning residents for full abandonment review, even with a valid green card in hand. A re-entry permit still helps but is no longer a guarantee of return, especially if ties to the U.S. appear weak. Evidence such as a U.S. home, job, or family remains crucial to proving permanent residence and must be shown if requested. Travelers who live abroad for work or family must now maintain solid U.S. records to avoid triggering abandonment procedures. Even short trips repeated frequently may raise red flags if they suggest you shifted your life outside the United States. If you must leave for extended periods, keep records, maintain U.S. ties, and consult an attorney before re-entry becomes an issue. The travel rules are active now. Green card holders are already being flagged, delayed, and questioned at major U.S. airports. Public benefits: use carefully or risk consequences. The confusion around public benefits and immigration just got some long overdue clarity, but also stricter consequences in 2025. This law officially separates emergency help from long-term government dependence when evaluating green card eligibility and citizenship readiness. Emergency Medicaid, disaster aid, and school meal programs are considered allowable and will not affect most immigration decisions negatively. But applicants relying on long-term cash assistance, subsidized housing, or extensive Medicaid usage are seeing negative flags in their files. If you've used benefits, you'll need to explain the duration, reason, and recovery plan to avoid suspicion of public charge concerns. USCIS officers are being trained to distinguish between survival help and chronic dependency, and the line is clearer but tighter. Nothing is automatic. But failing to report benefit use or downplaying it may now lead to denial or investigation. Transparency is critical. Applicants should disclose past benefit usage truthfully and provide supporting documents where needed to avoid penalties. Green card applicants and citizenship seekers should review their benefit history and prepare to justify it in full during interviews. This area remains politically sensitive, but it is now fully enforceable under the August 2025 immigration reform law. IRS and USCIS now sharing your tax data. One of the biggest changes in the August 2025 law is behind the scenes, and it's already affecting thousands of cases. USCIS is now actively cross-verifying green card and citizenship applications against IRS tax records for the previous 3 years minimum. Applicants with missed filings, inconsistent income reports, or prior audits are being flagged, delayed, or even outright denied. Failure to file taxes as a lawful resident is now viewed as a violation of immigration good moral character standards. Even innocent errors, like missing W-2s or reporting incorrect self-employment income, can trigger requests for evidence and further delays. Applicants must keep tax transcripts, pay stubs, and W-2s ready for submission and explanation if needed during processing. Amending past tax returns may help fix the issue, but proactive action is better than waiting for an RFE to arrive. If your income fluctuates, consult a licensed tax preparer or CPA to ensure you remain compliant throughout the immigration process. This collaboration between USCIS and the IRS is permanent, and it's already slowing down unprepared applicants who ignored past filings. In the 2025 environment, filing your taxes correctly is no longer just financial, it's an immigration requirement with legal weight. USCIS digital portal, faster but flawed. USCIS has launched a new case tracking system meant to speed up service and improve applicant transparency nationwide. The digital portal allows users to upload evidence, get real-time updates, and communicate directly with case officers if needed. But early reports show glitches, including account lockouts, document rejections, and updates that lag behind actual file processing. Some users report seeing decisions online before receiving official letters, while others experience delays or lost evidence uploads. Until the system stabilizes, applicants should take screenshots of every submission and keep hard copies of all communication and receipts. The portal is promising, but it's not yet reliable. Don't assume silence means progress or updates are always accurate. Log in weekly to check for messages, document requests, or alerts that don't get pushed via email or SMS. Treat the portal as one tool, not the only one, and always back up your uploads with physical copies if possible. This system may eventually improve processing times, but in 2025, it's still experimental and prone to technical breakdowns. If you experience issues, report them immediately and follow up through traditional mail or contact channels to ensure your case stays active. Timing is everything, and enforcement has already begun. The biggest mistake green card holders can make now is assuming these reforms take effect next year. They don't. Immigration attorneys confirm that cases filed after August 1, 2025, are already seeing stricter travel rules and tax-based RFEs. Green card renewals are being rejected due to long foreign absences or missing biometric updates under the new legal framework. Naturalization delays are hitting applicants with unfiled taxes, benefit usage, or poorly documented work and residency history. Meanwhile, cases with strong documentation, clean travel timelines, and complete tax records are being approved faster than before. Not all changes roll out at once, some will phase in over 12 months, depending on category and eligibility path. But the sections tied to fraud, taxes, biometrics, and re-entry intent are already live and impacting decisions in real time. Don't assume you have time, prepare now, adjust your records, and seek legal guidance before your next application submission. This isn't politics anymore, it's paperwork, enforcement, and digital surveillance in action. Your file must be airtight to survive. Every day you delay is a risk, especially if you've been relying on outdated guidance or past approvals to get through. Final thoughts: stay informed, stay prepared. This reform is not meant to scare immigrants, it's designed to reward those who follow the rules and stay compliant. Green card holders who maintain honest records, respect residency timelines, and prepare their files carefully can still thrive in 2025. But those who assume they're safe because they were approved years ago may face surprise denials, delays, or even removal. This is your moment to take control, not later, not next year, but today while the window for adjustment is open. Start with your taxes, your travel records, your benefit history, and your digital portal account. Get organized before they ask. And if your case is complex, or you're unsure how this law affects you directly, consult a licensed immigration attorney immediately. The new immigration system isn't just about who gets in, it's about who stays, and who's ready to prove they belong.
Like our video? Subscribe and comment to stay updated at US Immigration Hub.